city is still going to have the designated spaces. And what the court said is, that the court helped the city come to a decision to institute a method of designating the spaces, creating the I zones and the P zones, and the court agreed at the time that the city enacted its law in 2008 that a lottery system and a permit system would be an effective way, and he thought, the judge thought, a constitutional way of creating some order that would allow the spaces to be assigned in an appropriate way. But after the city adopted its law in 2008, the Ninth Circuit came down with another ruling in another case, a Seattle case called Berger versus City of Seattle. And in Berger versus City of Seattle, the court expressed, the Court of Appeal, Ninth Circuit Court of Appeal expressed some reservations and some concerns about a permitting system that's a little bit different from the one that we have, but the trial judge in this case found that it was close enough that we still were likely to lose a trial on the issue of our permitting system. And as a result of that, the city, he enjoined the city from having a permit system on the boardwalk. So what that means is a few things. It means that no longer is anybody who wants to use a designated space in the I zone or the P zone going to be required to first obtain a permit. It means, in fact, that permits that have been obtained in the past are not, they're really not going to have any meaning or purpose anymore, because there will no longer be a permit system on the boardwalk. As a result of that, there won't be enforcement based on permits. And as a result of that, the administrative enforcement that was based on holding a permit in the I zones that was that the recreational park monitors were involved in issuing notices of violation to people in the I zone who were vending products that weren't permitted by the ordinance before. The administrative enforcement and the ability to revoke a permit, all of that, appealing those violations, all of that administrative setup is no longer in effect because of the judge's ruling. So what that means is, it doesn't mean that there is carte blanche in the P zone or in the I zone. It means that the law against vending, all laws against vending that are in 4215 are still in effect. What's not currently in effect is a method of assigning the spaces. What's not currently in effect is Rec and Parks issuing notices of violation. So how are those violations going to be dealt with? Well, the LAPD is still empowered as they always were, except for the one area that Rec and Parks was active in. The LAPD is still empowered to enforce the provisions of Section 4215. And so rather than Rec and Parks issuing notices of violation that could result in the revocation of the permit, if violations occur in the I zone now, LAPD will be able to enforce the prohibitions on vending in Section 4215. And those, instead of being treated as offenses against a permit, will be treated as infractions for the first two offenses, and then the third offense would be treated as a misdemeanor. We're setting up and taking down before 9 and after sunset the prohibition on items over a certain height in performance spaces, and the large group rotation, or large group performing group space rotation. The court did not make any sort of ruling against the city on those particular allegations that have been complained with regard to this motion. Those issues are still alive in the case. I'm not sure exactly what may happen on some of those issues, because the judge, in essence, ruled that it's not likely that the plaintiffs are going to prevail on those issues. So if we press forward, those issues are still open, but at least in the judge's mind, it's unlikely that the plaintiffs will prevail. So it's it's unlikely that anything will change with regard to those rules. The future of the case, I'm not the litigator on the case, but the future of the case is that it may proceed to trial, it may be settled or otherwise terminated on the issues not ruled in as far as this motion is concerned. So, and there will likely be a status conference within the next couple of months on the case where the parties go in and talk to the judge and talk about how they're going to proceed. So I can't really tell you exactly when or how the rest of the case is going to be handled. Really mainly here to talk about what has happened as a result of this order. And I think I've given you the overview. I think to the extent that Arturo was saying, we might talk about what's going to happen next. I think in a lot of ways, we've given instruction for there no longer to be permits, no longer to be a lottery. We know one thing that I left out, and I was talking about that, I'm sorry, is that the judge indicated in the Seattle case that what the Seattle court, what the Ninth Circuit said, was that spaces can be allocated on a first come, first served basis. So I know we're going to be talking a lot in the near future with LAPD, with Rec and Parks, with the council office, about how to implement a system that is orderly with regard to first come, first served. But exactly what that's going to look like, none of us know right now. So I don't think I'd be able to have very much more to that discussion today. But that's one thing we'll be working on, is how to implement an orderly system for assignment of the spaces in the absence of the lottery. And I think with that, I think that's pretty much what I have to say.
Before we go to some questions, I don't know if you wanted to chime in, Sergeant? No, you're good?
What about Claudia?
It sounds good. Claudia, anything you wanted to add? No? Officer Thursey?
No.
Okay, great.
I wanted to ask you, while this issue is on the table, you know, we're merchants, we're trying to make a living, we're trying to survive. We don't have time to go down to hearings, but you know, one of the issues has been that it's unfair competition to us for this illegal vending on the other side. And two of the things that are preventing the police to be able to enforce this law in our favor is you've got this permission to give away anything on public land and accept a free will donation exchange in the P zone. That makes it where anybody can display anything. I can display a refrigerator, and if somebody wants to give me a donation, I can give them the refrigerator. And so what that comes down to is you got guys with handmade stuff, you got guys with stuff they bought from downtown, all on tables, belts, bracelets, necklaces, earrings, jewelry, stocking caps, anything you can go down to Santee Street and buy, you find it on those tables on the other side. And people are selling that stuff. And there's no way the police can enforce that because they're allowed to display that stuff there. Can we limit it to just letting them display paintings, photographs, prints, sculptures, buttons, bumper stickers, and pamphlets? Is that a possibility? Can we try to do something to help the merchants while we got this thing on the table, or else you're going to pass something and we're going to be back where we were for the last 15 years with it, man. We need some help, you know?
Well, I hear your comment. I can tell you that, you know, we've had pretty much 6 or 7 years of uninterrupted litigation with regard to the constitutionality of the vending ban. And although there's another lawsuit pending, the portion of 4215 that the judge did not rule against was the part that involved vending. And one of the things that was important to him last time when we rewrote the law in 2008 was that people be allowed to give away things.